So now the president has nominated Judge Merrick Garland, the chief judge of the D.C. Circuit Court of Appeals. But the Republican leadership in the Senate has made clear, as they've said all along, that they have no intentions of holding hearings at all on this nomination. Is there any precedent in history for the Senate simply refusing to consider a nomination from a president?
There is absolutely no evidence that I can find of a Senate ever denying a hearing to a president's nomination for the U.S. Supreme Court.
Never, not once, never.
Not once. It's amazing when you think about how unprecedented this would be, that there have been hearings held in order to oppose a president's nomination. And in fact, it would seem that opponents would want to take that opportunity to use Senate hearings before the Judiciary Committee to do so. But there is not one example of the Senate ever denying a hearing to a president's nominee for the U.S. Supreme Court.
And there's nothing in the Constitution that offers that as an option. I mean, we've talked about that the Constitution is actually sort of murky about the mechanics of this. The Constitution says that the president nominates someone, but with the advice and consent of the Senate. It doesn't lay out a procedure, but it certainly doesn't specifically say the Senate then can decide whether to consider that. I mean, the Constitution would seem to infer, I think it's probably a fair interpretation, that would seem to infer that the Senate must consider every nominee. There's certainly no provision that gives them the option of simply refusing to consider a nominee.
I think that's an excellent point to raise, that the wording of the Constitution is that the president shall nominate and, bind with the advice and consent of the Senate, appoint federal judges. So it doesn't seem to leave an option for the Senate not to take up that possibility. It gives them the option to advise in whichever way they wish, and it gives them the option not to confirm if one infers from advice and consent. If there is consent, there could also be non-consent, but there doesn't seem to be an option for no consideration whatsoever. We should also point out that hearings are a relatively modern element of this mechanism, that the Senate Judiciary Committee, as far back as the late 1900s, began to have hearings, but they weren't there from the very founding of the American Republic as we know it under this Constitution.